How do you resolve earnest money deposit disputes when selling property? Imagine putting down a deposit to show you're serious about buying or selling a property, only to find yourself in a disagreement over who gets that money when the deal falls apart. That's what an earnest money deposit dispute is all about. When a real estate deal doesn't close or gets canceled, the buyer and seller might disagree on who should receive the earnest money. Resolving this kind of dispute involves understanding the original contract, the role of contingencies, and the rules for handling the deposit. First, it's important to know that earnest money is a deposit made by the buyer to prove they are serious about buying the property. Usually, this money is held in an escrow account by a neutral third party like an escrow agent, a real estate broker, an attorney, or a title company. The contract should clearly state who holds the deposit and under what conditions it can be released. Common reasons for disputes include unmet contingencies. These are conditions in the contract that allow the buyer to back out if certain issues happen, like problems with financing, the appraisal coming in low, or inspections revealing major issues. Disputes can also happen if one party claims the other breached the contract, such as not disclosing important facts about the property. To avoid legal mistakes, both buyers and sellers should make sure all contingencies and contract terms related to the earnest money are clearly written and understood. It's also wise to include specific instructions about how the escrow agent should handle the deposit and how disputes will be resolved. When a dispute does happen, the first step is usually negotiation. The buyer and seller can try to work out an agreement directly, which is often the quickest and least costly way. If that doesn't work, mediation is a good next step. A neutral third party helps both sides reach a voluntary agreement without going to court. Mediation is non-binding, meaning the parties can walk away if they don't agree. If mediation fails, arbitration is the next option. An arbitrator listens to both sides and makes a binding decision. Arbitration is faster and less expensive than going to court, and the decision is final. Litigation is the last resort. If the parties cannot agree through other methods, they can take the dispute to court. A judge will decide who is entitled to the earnest money. Court cases can be costly and take a lot of time, and they might strain relationships between the buyer and seller. Usually, the escrow agent cannot releases the earnest money without a signed agreement from both parties. If they cannot agree, the escrow agent might deposit the funds with a court, and the parties will need to pursue legal action to get the money. This process can reduce the amount available because of legal and court fees. To prevent disputes, it's best to clearly state all contingencies and conditions for refund or forfeiture of the earnest money in the contract. Working with experienced real estate professionals and attorneys to review the contract before signing can help avoid misunderstandings. Clear and prompt communication about any issues during the transaction is also key. Including clauses that specify mediation or arbitration before going to court can save time and money. Understanding these steps and making sure the contract is clear can help both buyers and sellers manage earnest money disputes smoothly. Being proactive and precise in the contract can minimize legal risks and keep the transaction on track.